Hello everyone, we shall be making a start now for a different type of webinar this month. Instead of focusing on a particular topic of interest, I'll be presenting on interesting case law from 2019 and key takeaways we can learn from what has happened this year. And so a really warm welcome to you all and thank you for joining us today. We're going to start by introducing ourselves, if we may, just for those who haven't joined us before, and so you can know who we are and who you're listening to. My name is Abby Ashford, and I am a HR consultant for HR Solutions, and I shall be the lead presenter for you today. Sue Watson, our HR Operations Manager at HR Solutions, is also with us today on this webinar. We're joined by our colleague Ateeb, who is here to field any technical problems that I'm confident there won't be, but just in case. And a team will be monitoring and collating questions. So do please feel free to send her a message and then I will email you a response after the webinar is concluded. As always, we are recording this session, so it will be available for you to watch again if you wish to, and to share with colleagues if that would be helpful. If anyone wants to contact us afterwards for a copy of the presentation slides, then please note that you are very welcome to do so using the inquiries email address confirmed at the end of this webinar. And so onto the agenda, which is the interesting cases of 2019. Here's a list of some of those cases that we're going to be looking at. And we'll finish off with 3 personal liability cases as well, all based on data protection. Here's our first case to look at today, and that's Lee versus Asher's Baking Company. If you haven't had your lunch already, this piece of cake might make you getting hungry. Here we go. So, refusal to bake a gay cake was not direct discrimination. This was one of the most high-profile discrimination cases of the last year, perhaps even the decade actually. The baking company's name was derived from Genesis 49:20, where it says, "Bread from Asher shall be rich, and he shall yield royal dainties." It is run by the MacArthurs, this bakery, and they are Christians, and they hold the beliefs that, first of all, the only form of full sexual expression which is consistent with biblical teaching and therefore acceptable to God is that between a man and a woman within marriage. And also the only form of marriage consistent with biblical teaching is that between a man and a woman. They have sought to run Asher's in accordance with their beliefs, but have not published any biblical connections or made their beliefs known to the public. They employ gay people, they serve gay customers, and Mr. Lee has even been a customer in the past, albeit neither party were aware of each other's positions. Lee placed an order for a cake which he intended to take to an event held by an organisation called Queer Space. He asked for the cake to be iced with an image of Sesame Street characters Bert and Ernie, the Queer Space logo, and the wording "Support Gay Marriage." The bakery took down the order without raising their reservations. They telephoned Mr. Lee a few days later to apologise and explained that they were unable to fulfil the order because of their religious beliefs and made a full refund to him. So, although not an employment law case, the high-level ruling which makes findings on equality law and human rights conventions has important bearings on discrimination cases in general. Mr. Lee brought a discrimination claim and succeeded at both the Northern Irish courts and the Northern Irish Court of Appeal. However, the decision was overruled by the Supreme Court. It looked at direct discrimination on grounds of both sexual orientation and political belief. It was found that the bakery had not refused to bake the cake because of Mr. Lee's sexual orientation, but because of the message that would be on the cake. His own sexual orientation had been irrelevant, and so it could not be found that Mr. Lee had suffered direct discrimination. If anything, he had suffered discrimination by association with the gay community. However, for discrimination by association to succeed, there must be a particular person who the claimant is associated with. It was found that association with the gay community in general is too broad. In a nutshell, the bakery's objection was to the message and not to any particular person or persons. For these reasons, the claims for discrimination on the grounds of sexual orientation failed. When considering the grounds of political belief, the court heavily considered Articles 9 and 10 of the European Convention on Human Rights. It particularly focused on the entitlement not to be forced to express a political opinion, which you do not believe in. It was found that infringing these fundamental rights could not be justified in respect of a requirement to ice a message on a cake, which the bakers profoundly disagreed with. So what are the learning points for this case? Well, this case casts doubt on whether employers may take a dim view on those who refuse to provide a service asked of them because of their beliefs. There may be some circumstances where employers can refuse to do something because of a profound belief that to do so is contrary to their beliefs. So an interesting one there. Moving on to another interesting case, and this is Royal Mencap Society versus Tomlinson Blake. In this case, the England and Wales Court of Appeal considered what rate of pay a worker was entitled to when they were contracted to spend a night at their workplace, but they are expected to be asleep for the shift, except for when they may need to be woken for a specific duty. The question to be addressed was whether the whole of the period spent at the workplace should be taken into account for the purposes of calculating the national minimum wage, or just the time spent doing the activity they were woken up for. At the EAT, it had been ruled that the entire period should attract the national minimum wage. The appeal disagreed and reverted back to the generally held understanding that only the time which the employee was required to be awake attracted the national minimum wage. It made the distinction between being available to work as per section 15(1)(32) of the national minimum wage regulations and actually working as per section 15(1)(a)(32). This is a very significant ruling for care agencies. As well as being a very significant ruling for the care sector, it's important to remember the distinction in rules between working time for the purposes of the working time regulations and working time for the purposes of national minimum wage as presented in this case. For the purposes of working time regulations, if the worker is required to be present at the place of work for the on-call period, then all of the time will count as working time. This applies even when the worker is free to sleep during the on-call time but may be disturbed. Also, periods of inactivity spent sleeping do not count towards the obligation to give workers a certain amount of rest breaks. In addition, if the location is restricted to remaining at home or within close proximity of the workplace, then the time spent during this period is under the employer's control and is therefore working time. Our third interesting case is that of Talon Engineering Limited versus Smith. Smith was summarily dismissed following 21 years service. She had sent emails to a contact describing a colleague as a knob and a knobhead, and she attempted to delete some emails which were later retrieved. The employer believed the content of these emails brought the company into disrepute and were in breach of the bullying and harassment policy. However, the process was deemed to be fundamentally flawed. Smith was suspended on the 29th of July 2016 and attended an investigation meeting on the 9th of August, but she was not shown any evidence against her. On the 26th of August, she was invited to a disciplinary hearing on the 5th of September 2016, which was postponed because of her own sickness, followed by a period of annual leave. On the 19th of September, she was invited to a rescheduled disciplinary hearing 10 days later, on the 29th of September 2016. Her trade union official was unable to attend at this time and provided 3 alternative dates, which were almost 2 weeks later. The meeting was not postponed as it was believed that further delay would add undue strain. As part of the defence, it was also pointed out that the employer was entitled to reject the request because the proposed dates were not within 5 days of the original date of the hearing as per Section 10 of the Employment Relations Act. The employee refused to attend without the union official, and so the hearing was carried out in her absence. The tribunal and appeal tribunal agreed that the decision not to allow a further delay to allow accompaniment rendered the dismissal procedurally unfair. It pointed out that the 5-day time frame was a requirement under the statutory right to be accompanied. However, a breach of this right was not being claimed. What was being claimed was that the dismissal was unfair as per Section 98 of the Employment Rights Act 96, which requires fairness to be determined in accordance with equity and the substantial merits of the case. It is here where the concept and requirement of consistency, impartiality and fairness comes into effect. A delay had already been allowed, and it was deemed that a further delay would have been reasonable, particularly considering that A, the delay was considered to be relatively short, B, it is always preferable that the employee attends, except where reasonable attempts have been made to allow this to happen and the employee is perhaps deliberately trying to inconvenience the employer. And C, her long length of service meant the refusal was unduly hasty. In this case, the employee won an unfair dismissal claim and was awarded a basic award of just over £11,000 and a compensatory award of just over £10,000. The tribunal agreed that these were reasons to be disciplined, although suggested it may not have been gross misconduct, and this meant that her award was 15% lower than it would otherwise have been, due to contributory fault on her part. So the learning points from this case: when making decisions on approach, employers should not only consider their statutory obligations, due consideration must also be considered to consistency generally and to what would be considered reasonable and fair in the context of the particular circumstances. It is a reminder actually that tribunals will consider an employee's length of service and that they will give preference to facilitating an employee's attendance at a formal hearing which results in a dismissal over brief delays. Although it was not a key aspect in the outcome of this case, we should also remember the importance of considering whether an employee could have known in advance that their conduct was likely to be regarded as gross misconduct. If not, then gross misconduct is likely to fail. Okay, so moving on to another case. Royal Mail Group Limited versus Duty. In this case, we're looking at unfair dismissal bias in the process. And looking at the background, in a claim for unfair dismissal, can this be the reason for dismissal other than that given to the employee by the decision maker? Well, yes. If a person in the hierarchy of responsibility above the employee determines that she or he should be dismissed for a reason but hides it behind an invented reason, which the decision maker adopts, the reason for the dismissal is the hidden reason rather than the invented reason. In terms of the background, the case started when Miss Duty raised an internal concern as a result of a colleague who she had concerns about not complying with Ofcom's guidance in relation to tailor-made incentives, or TMIs, for new customers. After raising these concerns, Miss Duty appears encouraged to withdraw her concerns, which she did, but then subsequently became the victim of a campaign to discredit her and to manage her out of the business, a point that she had flagged to her manager at the time. Miss Duty was eventually dismissed in July 2014, but not after having been offered 3 months' pay for her to voluntarily resign, which she rejected, and this offer was increased to 12 months' salary, which Miss Duty also rejected. In September 2014, Miss Duty appealed the dismissal, and it took the company until August 2015, almost a year later, to dismiss the appeal, a point which the tribunal found to be unsatisfactory. In the meantime, Miss Duty had submitted her claim to the Employment Tribunal in March 2015. This case spans many years, starting back in 2013, and has just had a judgment issued at the UK Supreme Court, following an Employment Tribunal appeal, and the Court of Appeal. This case spans many years, and the ruling is of interest because if a person in the hierarchy of responsibility above the employee determines that he or she should be dismissed for a reason, but hides it behind an invented reason which the decision maker adopts, the reason for the dismissal is the hidden reason rather than the invented reason. So on to our learning points from this case. We need to ensure that all internal processes are free from bias. We need to allow managers that manage an appeal process to be able to reinvestigate the case if they feel it is necessary. We should be clear as to the reasons for a dismissal and not fabricate a fair reason to hide an unfair reason for dismissal. Also, waiting 12 months to dismiss an internal appeal is unsatisfactory. We should be encouraging employees to speak up about internal concerns as opposed to victimising them. A further case affected by this judgment is Cadent Gas Limited versus Singh. In this case, the respondent appeal was rejected on the basis of this Royal Mail Group versus Duty case I've just been through, where the motivation and knowledge of someone who is not a decision maker may be attributed to the employer if, as here, that person is engaged in and had manipulated the investigatory process. Our fifth interesting case is that of Jagex Limited versus McCambridge, and this is from September 2019. Have you ever sent an email to the wrong recipient, or perhaps sent a confidential document to be printed on the wrong printer? Well, we've all heard of this kind of error being made in an office environment and perhaps witnessed a colleague's shock and realisation when it's all too late. Well, in this case, the claimant was dismissed after viewing a document on a communal printer that had a senior employee's pay on it. He pointed the document out to a colleague as they were passing the printer. Later on, someone started off a game to guess which senior employee's pay this document referred to, and the claimant who was dismissed wasn't actually participating in that game, but had their employment terminated on the grounds of gross misconduct for disclosing the pay details. He was brought into an investigation meeting, and then the same manager dismissed him. The claimant succeeded in his claims for unfair and wrongful dismissal, and no deduction for either contributory fault or a POLGI reduction was made. The matter was adjourned for a remedy hearing, and the EAT dismissed appeals against a finding that that was not gross misconduct under the contract and that there should be no POLGI reduction. A more fair procedure would not have made the dismissal fair, it was deemed, because the approach was too heavy-handed anyway for an employee with 6 years clean service. There was no express term about confidentiality of salary information, nor could they be written into the employment contract. There was no breach of contract and therefore no gross misconduct, it was decided. The tribunal had also decided that there should be no reduction for contributory fault, as the disclosure was not gross misconduct, but the EAT said that they should have considered if the claimant was blameworthy at all to determine if any reduction should be made. Think not only about the procedure, but also about the fairness of decision making. And don't let pride or emotion get in the way of making the right decision about someone's employment. That's one of the key takeaways from this case. Think, is there another form of action that will deal with the matter in hand adequately? Also, whilst there is the Polkey principle to rely on, we should be in the practice of having a separate manager to lead each part of a disciplinary process, being the investigation, the hearing, and the appeal, where there are enough managers. If you only have 2 and not 3, then you should at least reserve your most senior person for the appeal. Our 6th case is from November 2019, so very recent, and that's Dewhurst versus Revised Catch, trading as eCourier, and City Sprint. This company is a cycle courier business that hired contractors who provided services for both eCourier and City Sprint. The claim was against both companies for not duly consulting with them about a contract transfer. As TUPE only applies to employees, this case looked at whether they were contractors or workers, and if workers, whether Regulation 2 of the TUPE legislation covered them. The employment judge ruled that TUPE applies to workers as well as traditional employees, and that's the key takeaway from this case. Her reason was that the Acquired Rights Directive requires TUPE to be interpreted widely, and the definition of employee in TUPE is an individual who works for another person, whether under a contract of service or apprenticeship or otherwise. The words of otherwise therefore must be taken to extend the definition of employee and therefore covers what are known as Limb B workers. The learning points. Limb B workers are those who don't quite meet the criteria for employee status, but are not sufficiently independent of the organisation hiring them to be considered as self-employed. Therefore, a Limb B worker is an individual that A, works under a contract personally to do work, and B, the work is done for another party to the contract that is not a customer or client of a profession or business undertaking carrying on by the individual. An example of a Limb B worker could be a self-employed labour-only subcontractor in the construction industry where they work for long periods of time for the same employer as an integrated part of their workforce. Our 7th case is Consisby versus Crossley Farms Limited, a really interesting case where the claimant had been employed from April 2018 until he resigned on the 30th of August 2018. He worked as a waiter, barman, and the grounds for complaint were discrimination on the grounds of religion and belief, and a claim for notice pay. But the most important and interesting element is that the discrimination was based on vegetarianism being a protected characteristic under the Equality Act 2010. So let's get into this case. With Consisby versus Crossley Farms Limited, you may be aware already that the Equality Act 2010 introduced a wider definition of what were safeguarding religious beliefs to cover philosophical beliefs as well. In this case, Ms. Consisby failed to establish a case for vegetarianism to be afforded discrimination protection. The tribunal concluded that it is simply not enough to have an opinion based on some real or perceived logic, and goes on to affirm the respondent's argument that vegetarianism is not about human life and behaviour, It is a lifestyle choice, and in the claimant's view, believing that the world would be a better place if animals were not killed for food. While believing this was an admirable sentiment, the tribunal did not believe it could be described as relating to weight and substantial aspects of human life and behaviour. I'm now going to move on to 3 personal liability cases, all to do with data protection actually. And the first one is that of Heart of England NHS Foundation Trust versus Cooley from March 2019. Ms. Cooley was authorised to access records of adults, but an internal investigation found that Ms. Cooley viewed personal data of 7 family members on their iCare system and 7 children known to her too. There was no business need for her to do this, and so she therefore broke data protection law. She was fined £1,000 with a £50 victim surcharge and was ordered to pay £590 towards prosecution costs. Obviously, the learning point with this one is that employees can face criminal prosecution if they access or share personal data without a valid reason. Our second personal liability case is that of V12 Sports and Classics Limited versus Morgan Davis, also from March 2019 this year. This is another data protection case where an employee had not appreciated that they could be held personally liable for not safeguarding personal data. Ms. David forwarded several work emails containing personal data of customers and other employees to her personal email account in August 2017, weeks before resigning from her role at V12 Sports and Classics Limited. She admitted to 3 offences of unlawfully obtaining personal data in breach of the Data Protection Act and was fined £200 with a £30 victim surcharge and was ordered to pay $590 towards prosecution costs. We've all been on the receiving end of a phone call informing you that the caller is aware of your recent road traffic accident, right? Well, in this case, a former managing director of a claims management company, David Cullen, was found to have unlawfully obtained and sold personal data, and he was prosecuted in June of this year. David Cullen was the managing director of Number One Accident Claims Limited, based in Manchester. The core business of the company was the obtaining and subsequent sale of personal data relating to policyholders of car insurance who had been involved in road traffic accidents. Mr. Cullen appeared before Manchester Crown Court on 21 counts of unlawfully obtaining and selling personal data in breach of Section 55 of the Data Protection Act. He was sentenced to a fine totalling £1,050, ordered to pay costs of £250, and was disqualified from being a director for 5 years. Confiscation under the Proceeds of Crime Act 2002 was commenced with the benefit figure from the illegal activity totalling over £1 million, and due to Cullen's lack of assets, a nominal order was made. So that concludes the personal liability. Just going to have a little look at the legal impact on employment law so far this year. Whilst we have the results of the general election in the early hours of tomorrow morning, we turn now to have a look at this impact, taking on board that it's difficult to be clear on what new employment law we will be impacted by, depending on who gets into government. There have been a number of technical notices, white papers, and regulations introduced. We will consider just a few of these, but in doing so, we'll cover off the general impacts that the changes have had on employment law so far. First of all, let us look at the future relationship between the UK and the EU policy paper that was issued this time last year. This document was actually published after the Withdrawal Act. However, despite being 104 pages long, it only has this section which discusses employment in any degree of detail, and even then it is sparse. If you don't wish to be bogged down in the legal jargon and technicalities, what we can get from it is a neat summary of the effect of the Withdrawal Act. Namely, it ensures that existing rights derived from EU law will not disappear on the day of withdrawal. They will be in place until further notice. It also proposes a commitment to the non-regression of labour standards. For information on what is being discussed, we look to the EU Withdrawal Act 2018. This Act ingrains existing EU employment law into UK law, bringing across the powers from the EU directives. Small amendments to the language of workplace legislation are being made to reflect the fact that the UK would no longer be an EU country. This Act ingrains the Act repeals various pieces of legislation, such as the devolution of power, and gives control back to the UK. This control would ensure that EU-derived domestic laws and direct legislation, subject to any exemptions, would continue to have effect on and after the day of the UK's exit from the EU, therefore allowing the UK government to keep initial control. With reference to our courts and tribunals, the Withdrawal Act provides that we will not be bound by any principles laid down by the European Court of Justice on or after exit day, and cannot refer any matter to the ECJ either. The Supreme Court is not bound by any retained case law, and the High Court of Judiciary, Scotland's Supreme Criminal Court, is not bound by any retained EU law in certain situations. For information on what is being discussed, we can look to the Employment Rights EU Exit Regulations. These are still in draft form, presumably pending a deal, but the Employment Rights Amendment EU Exit Regulations 2018 make amendments to employment law to reflect the withdrawal of the UK from the EU in the event that there is no deal with the EU. The amendments ensure the legislation is clear by removing or amending language that is no longer appropriate once the UK has exited the EU. It sifts through and amends these regulations. It amends the Employment Rights Act 1996 in relation to parental leave. It amends the Employment Relations Act in relation to part-time work. It also amends the Employment Act 2002 in relation to fixed-term work, and amends various secondary legislation such as the Working Time Regulations, the Employment Tribunal's Constitutional Rules of Procedure Regulations, and in relation to evidence from other EU member states and references to the ECJ. And finally, the Posted Workers Regulations of 2016. For information on what is being discussed, we also look to the Employment Rights EU Exit No. 2 regulations. These regulations make changes that will be necessary if we leave the EU tentatively, irrespective of whether this is with a deal or not. The Draft Employment Rights Amendment EU Exit No. 2 regulations make amendments to legislation in the field of employment rights, removing or amending references that are no longer appropriate once the UK has exited the EU and are subject to the affirmative procedure, i.e. they will need to be debated in Parliament. For example, we increased the minimum annual leave entitlement to 5.6 weeks with reference to the EU entitlement of 4 weeks. They have removed the reference to EU entitlement and will just be 5.6 weeks. So as per these draft regulations, we have amended wording of the ERA 1999 to enable TUPE-like regulations to continue to be made. We amend the Section 13 of the Work and Families Act 2006 to enable regulations regarding annual leave to continue to be made, which amended the Working Time Regulations of 1998 to provide for additional annual leave, i.e. increase the annual leave entitlement from 4 to 5.6 weeks. Whew, right, we have been through a lot of intense information there, and I hope you found that very interesting by going through the cases that we thought were most relevant with their key takeaways, going through personal liability cases too. This is the end of our webinar today, and for those listening and watching who are already clients of ours, thank you so much for joining us again today, and please do contact us in the usual way if you have any follow-up queries. If you aren't a client with us already but would like to ask a question or are interested in our services, then please do contact us at inquiries@hrsolutions-uk.com. You can also use this email address to request a copy of our slides from today, and you can watch, listen, forward our webinar recording from today by heading to our main website at www.hrsolutions-uk.com and clicking on resources and then video and webinar archive. Please sign up on the events page on either our knowledge base if you have access to this or on our main website. The next webinar that we have planned will be in the new year, looking at what's new for HR in 2020. And for your information, this webinar and all of our previous webinars are recorded and can be found on our website or knowledge base. On the slide at the moment, you can see the various webinar recordings that we have done this year that you can have a look and watch again. If you've not already signed up to our newsletter, then this is just a reminder of the link. Signing up will mean that you get to hear about our latest webinars and events first, and also keep abreast of any other developments. We have some free HR risk audits on our website and knowledge base. Link is on the screen for you. Each audit taken will generate a bespoke report based on your responses, allowing you to focus on any areas that need attention. There's also a Brexit audit and a GDPR audit too if you're interested. All I have left to say is thank you for listening and that I hope you found today's webinar informative. Thank you.